Dear students, I, Sunita Tripathy, am an assistant professor at the Jindal Global Law School, where I teach courses related to intellectual property law. Today we shall discuss the module on the concept of distinctiveness and the grounds for refusal of trademark registration. The aim is to familiarize you with the fundamental concepts of distinctiveness as a notion required for trademark protection and the relevant absolute and relative grounds for refusal of such registration, the legal provisions as well as case law. At the end of the module, you are expected to have grasped the fundamental concepts of what is known as acquired distinctiveness and inherent distinctiveness, the contradictions and tensions between confusingly similar trademarks for goods and services, as well as be able to conduct case law analysis to identify the relevant legal principles supporting decisions pertaining to the grounds for refusal of such trademark registration. Let's begin with some fundamentals first. Trademark as such needs to have a notional function. The function essentially is to mark the source of the good. So if we are to explain the functions of a trademark, they are firstly to indicate the origin of the product, that is, one good can have only one origin, that's the presumption. The second, the quality of the product, which is related to the goodwill of the business, and finally to differentiate the product, and this is the distinguishing factor which is also going to be discussed at length under the notion of distinctiveness. The idea is that the trademark would then distinguish market goods and services from those of its competitors. As such, registration for trademark is not necessary because the life of a trademark essentially depends on its actual use. The section 47 of the Trademarks Act 99 itself provides that the trademark may be removed from the register in case of non-use. However, what is important here is the term and the length of protection afforded to trademark once it is registered. The initial registration of a trademark is for a period of 10 years, which may then be renewed from time to time upon payment of renewal fees, which can go on to perpetuity. So in a sense, a trademark protection can last from 0 to infinite number of years, and that is why traders look to register trademark. Section 6 of the Trademarks Act provides for the registry, and after the amendment of the 99 Amendment Act of the Trademarks, there is a single register with a simple procedure with no two Part A, Part B legal rights and distinctiveness required registered, but essentially it is just one single register to facilitate easy trademark registration, that being the latest. Let's go back to understanding what is this notion of distinctiveness and why is it so important a registrability criteria for a mark. Essentially, distinctiveness is required to exclude marks which do not even perform the basic function of distinguishing between two goods and products. The courts have held in the matter of Imperial Tobacco versus Registrar in the year 1977, and this is a Calcutta High Court judgment still reiterated several times, to define distinctiveness as some quality in the trademark which earmarks the goods so marked as distinct from the other products or such goods. So the idea is distinctiveness may either be inherent or even acquired, and the notion of distinctiveness is essentially to segregate between two competitors' goods and services. So an ideal trademark according to Indian Trademark Act would be one which is distinctive, which is non-descriptive and not generic. For example, Yahoo for a search engine. Yahoo as such is an invented word, has no specific dictionary meaning, and when attached to a product and service such as search engine, goes on to emanate a new function of distinguishing that search engine from its proprietor. Acquired distinctiveness is also known as secondary meaning in the United States. It may be assessed based on several factors which include customers' perception of displaced primary meaning in the mind of the consumer, the exclusivity of the use, the manner of the use, the duration of such use, and the volume of goods marketed, advertisements, and consumer surveys. Essentially, marketing and strategies go on to decide a consumer's preference, and that goes on to be called as acquired distinctiveness. What would be inherent distinctiveness? Before we go on to understand that, let's familiarize ourselves with a few terms and words associated with the kinds of marks. And I'm going to rely on Justice Learned Hand's judgment in the case of Abercrombie and Fitch versus Hunting World, where Justice Hand essentially goes on to describe a spectrum of distinctiveness to assess the strength of a mark. And this spectrum goes on from the strongest mark being a fanciful mark. A fanciful mark is one which is absolutely imaginative, creative, never known to the world before. The best example for such would be an invented word such as Kodak for camera. Kodak as such has no meaning, but when attached to the service of camera, goes on to inherently become distinctive and new, and therefore is easily identifiable by the consumer looking to buy and purchase a camera from Kodak. The next strength of a mark would be assessed on the basis of what is known as arbitrary marks. Arbitrary in a sense would mean something which is not reasonable, and therefore you go on to attach a meaning of a separate word and juxtapose it to the goods and services which is different from the characteristic of that word to go on to build a new meaning. The best example of that is Apple computers. Apples are fruits, and no computer is essentially a fruit marketing. However, when you attach a word such as apple to computer, it goes on to evolve a new meaning and attaches itself to the consumer who's looking to buy a computer which is labeled as Apple, because it originates from a particular company and has a certain quality standard as and when the consumer requires to be buying it. The next standard would be what is known as suggestive mark. A mark would be known as suggestive when a certain degree of imagination leads the consumer to associate and identify that mark to the good. For example, to reach a conclusion as to the nature of the good essentially would be without describing the quality of the good. The best example that comes to mind is Jaguar for the fast car. Jaguar is a fast animal. However, when you attach a word such as Jaguar, an animal, to a fast car, it essentially means that these cars are fast moving vehicles, and that is what a consumer goes on to understand from such labeling. Next would be a descriptive mark. Now, descriptive marks in a sense are known to be weaker marks because they go on to describe the character or the quality of the mark in itself, and thereby not being helpful in distinguishing goods and products, because in a sense most of the goods in the same class would have the same distinguishing feature. And so a descriptive mark is really not a strong mark but a weak mark. The best example of that would be an example of lens cart for optical lens markets, or even computer land for a place which is known as a computer store, which essentially means it's a land of computers or it's a cart of lens. Nothing much to be described more. The aim is essentially to protect the public by keeping descriptive signs and indications for use of all traders, and so that nobody essentially goes on to have a monopoly-like right over these public domain words, for the simple fact that they can be descriptive and be useful to other traders in the trade as well. And finally, what is known as generic marks. Generic, as it suggests, refers to the genus of a particular product as a species. Essentially, these words are customary to trade, and therefore they are taken away from the domain of protectability as trademarks. And the examples of such would be words such as, say you are selling a product, milk product, and your product is termed as milk. In a sense, every other person who is in the business of milk parlor will not be able to use the word milk for the product, and therefore you are not allowed to be labeling or using a mark such as milk for your product, which is milk. The other phenomena which is upcoming is what is known as genericide, and that's an unfortunate incident when an absolutely fanciful and invented word goes on to remain in the public memory for so long that it becomes attached to the good itself. The example for such case would be Xerox. Xerox was an invented word attached for the service of photocopying. However, today in time and age, people use Xerox as a substituted word for photocopying, and thereby there is confusion if Xerox is a company in itself or the function or the art of photocopying. So it might come back to be becoming confusing in differentiating between two kinds of photocopying machines.